Get ready. 3, 2, start. This revision has been filed against concurrent judgments of the courts below ordering eviction of the petitioner from the premises in dispute on the petition for eviction filed by the respondent. Learned senior counsel has raised two arguments. His first argument is that the landlord respondent did not disclose that he possessed numerous other properties, and this is fatal to his claim. A perusal of the judgments of the courts below reveal that the courts have taken into consideration the fact that properties were originally owned by the father of the landlord, and he had 9 other brothers and sisters, and therefore the authorities held that even though some of them may be lying vacant, it could not be said that they were in the possession of the landlord. Learned senior counsel has argued that it is well settled that the possession of one co-sharer is the possession of all the co-sharers, and therefore it was incumbent upon the authorities to have held that the respondent was in possession of those vacant properties, and his non-disclosure disentitles him from relief. The second argument raised by learned senior counsel for the petitioner is that there was no pleading by the respondent in his petition that his son, for whose benefit the personal necessity was claimed, was not possessed of any other property in the urban area, and for this he has relied upon case law wherein it has been held that it may be pointedly mentioned that in terms of the statutory requirement, landlord was not only to plead such facts about himself, but was also to plead such facts qua his son, as well as whose need as well. He had set up a case of personal necessity. It is a conceded fact that there is complete blackout in the petition that son of the petitioner that was not in possession of any other non-residential premises and had not vacated any such premises in the town after coming force of the act. In the present case, there is not even a whisper by the petitioner that the son of the landlord respondent possessed any other property in the urban area. In these circumstances, the omission to plead that his son did not own or possess or had vacated any other property in the urban area would not be fatal to the case of the petitioner. In the circumstances, The petition is dismissed. Stop.